Hello, I'm ISBA President Paula Holderman. Today it is my pleasure to talk to Joe Hudson, a prosecutor in the Cook County State's Attorney's Office, who will receive an ISBA Presidential Commendation at the Board of Governors meeting on May 2nd. Welcome to the program, Joe.
Thank you.
So we will be honoring you at the Board of Governors meeting, and it involves a complex UPL case that you handled, and from what I understand, it's beyond the traditional UPL case. Can you tell us a little bit about it?
That's right, Paula. In your traditional UPL cases, unauthorized practice of law, it would typically involve someone who had no association whatsoever with an attorney, and they would essentially represent to a member of the public that he or she could do the work of an attorney, and typically in a situation where they would ghostwrite papers for a pro se litigant. Again, that's the typical situation. What we're seeing increasingly in modern day is non-attorneys who are actually affiliating themselves with an attorney as part of an ongoing business. And typically these are businesses that have some aspect of the law related to their operation: credit repair, loan mediation, foreclosure avoidance, debt collection. And you might ask yourself, why would a non-attorney want to affiliate with an attorney? It's because there's been a number of statutes enacted both in Illinois and in other jurisdictions that essentially place onerous requirements on non-attorneys practicing in these areas. If you're a non-attorney in the credit repair business or the loan mediation business or the debt collection business, often you have to obtain some type of license or bond. In many cases, you can't collect a fee up front. And in other cases, there are numerous disclosures you have to make in writing to the customer. If you're an attorney, for the most part, you're exempted from these requirements. So that's why it's so attractive for these non-attorney businesses to affiliate themselves or recruit an attorney to be essentially their front person or to work with them.
Now, as I understand it, this case involved mechanics liens. Is that correct?
That's correct. The case at hand involved mechanics liens, People versus Contractors Lien Services and Stephen Boucher. Contractors Lien Services was one of the largest bulk creators and recorders of mechanics liens. At times, they would record hundreds of liens a month. They would actually prepare the lien and record the lien. And why this was so attractive is there are numerous general contractors and contractors out there who are owed for work that are done and simply can't get the money themselves from the property owner. So the enticement would be, for a flat fee, companies like Contractors Lien Services would offer and in fact prepare the lien, record the lien, and send the lien to the property owner. And in some limited situations, they would even negotiate the payment of the lien with the homeowner. Many of these activities are traditionally done by an attorney. Our office received a number of complaints from members of the public, particularly property owners, about these liens.
And was that because something had gone wrong?
That's correct. In many cases, Paula, we were seeing liens that had grossly excessive amounts that had been liened. We were seeing what I would call junk fees. These are recording fees and release of lien fees and mailing fees and filing fees that were essentially added to the underlying lien, and in many cases inflated the overall value of the lien by 2 or 3 times.
So the public was being harmed, in other words?
Absolutely. These are some of these situations. There may have been a legitimate lien issue, a non-payment issue that may have justified a lien, but certainly not for the amount of the underlying lien.
And how long did this go on, Joe?
This case, Paula, was started in December of 2008.
Okay.
And upon filing the case, actually, Contractors Lien Services ceased doing business. And the case wasn't resolved until the December of 2013.
So 5 years?
5 years with consent agreements with the company and with Mr. Boucher. And it was a very long process. Our office filed a lawsuit, and so did the Illinois Attorney General's office at the same time. But there were 2 bankruptcies, numerous different legal representation for the defendants, and there were a number of knotty issues about what constituted the unauthorized practice of law. Does a mechanics lien constitute a debt? Is Mr. Boucher or Mr. Boucher's business, Contractors Lien Services, somehow exempt from various statutes?
Well, Joe, it sounds like you have just done a heck of a job on this case over a very long period of time, and I want to thank you for being with us today to shed some insights on this significant UPL case. And as I said, for all the great work that you and State's Attorney Alvarez have done on this. And so congratulations on your award. I am Paula Holderman. Thanks for watching, and we will see you next time. Thank you.